And Jenna, if
Madam
you
Chair,
would.
point of order.
Yes,
Do we have any bill introductions this morning?
there are no bill introductions allowed.
Thank you.
Yesterday was the first day, the last day. Thank you, though. Okay, Jenna, if you would begin with the bill brief. Thank you.
Good morning. Thank you, Madam Chair, members of the committee. Senate Bill 3 requires the Department of Health and Environment to audit hospital compliance with the Lay Caregiver Act and report the results of that audit to the legislature. It amends KSA 65431A, which is the Kansas Lay Caregiver Act. Under this law, a hospital is required to provide each patient the opportunity to designate a new caregiver upon that patient's discharge from an inpatient stay at a hospital. If the patient chooses to designate a caregiver, the hospital is required to reach out to that caregiver or attempt to contact the caregiver and provide discharge instructions and education for the aftercare of the patient. This bill adds a new subsection F on page 3 of the bill to this statute, and it would require that the Department of Health and Environment verify that each hospital is complying with the act. Beginning in 2026, the department is required to audit hospital compliance and compile the results of this audit into a report that would be given to the House Committee on Health and Human Services and the Senate Committee on Public Health and Welfare on before January 31st of each year. I'll be happy to answer questions.
Any questions for Jenna, committee? Seeing none, thank you, Jenna.
And I should note that this comes to you from the Legislative Post-Audit Committee.
Okay, thank you. Committee, we will begin with our oral proponent. We have Jody Fowler. Jody, are you in the room? I'm sorry? Oh, she's virtual. Okay, and it does say, thank you. Jody, can you hear us?
I can hear you.
Very good. Please go ahead.
Thank you. Thank you, Chair Beverly Gossage and the committee for letting me testify today. I am here as a proponent of Senate Bill 3 as the daughter of Sharon Fowler, who passed away on 8/9 of 2023. I'm testifying as a proponent because the CARE Act signed into law by then Governor Brown back in 2018 was violated in the case of my mother. I believe it has happened to one patient and one legal guardian. It's happened to several and not just by one hospital. The main points of my story about my mom, I will refer you back to the written testimony for more detail and the attachments included within. I was my mother's legal guardian because she had dementia and had been declared incompetent to make her own decisions. The hospital was very aware of this information and in fact called me to ask for permission for certain testing to be completed, but yet failed to notify me that she was being discharged, let alone the right to sign the immediate letter for Medicare explaining the rights to appeal her discharge plans, review her discharge plans, and see that she was discharged with dignity. I don't believe my mother's passing would have been delayed just simply by following the CARE Act. However, her discharge plans would have looked different had I been given the opportunity as her legal guardian and caregiver to appeal the right of her discharge. She was discharged to go back to a skilled nursing unit, which was a change in level of care. She left the nursing home as a resident and returned to the nursing home in skilled nursing. I don't know if any of you have had a lived experience with this, but I had a right to choose a different skilled nursing unit. I didn't have to send her back to the nursing home that she left from, and I was not given that ability. I wasn't impressed with the skilled nursing unit at that facility, and in fact would have chosen a different facility for skilled nursing unit. However, within 5 to 6 hours of her discharge, she was placed on hospice care. Had I been given the right to appeal her discharge, it would have bought enough time for them to look at my mother's passing and dying in their facility to have a discharge plan to hospice care rather than skilled nursing. I'm a strong advocate for vulnerable citizens, whether they be children and families or patients and caregivers. I would beg of you to please pass the Senate Bill 3 to reduce the risk of what happened to Sharon Fowler so that it does not happen to anybody else or their caregivers. This is not an isolated incident. I cannot believe it's an isolated incident, and my complaint is not about just one specific hospital. Again, if it happened to me, if it happened to Sharon Fowler, it's happened to more than one person at this hospital and likely across the state. When the audit was requested, it was pushed back with rights about HIPAA. I believe that can't be a block for audits to happen with hospitals. Again, I want to thank you for your time, allowing me to testify and share my mother's story with you today. And I beg of you, please pass Senate Bill 3 so this doesn't happen to other families, or at least greatly reduces the risk of it occurring to other families and caregivers. Ultimately, I think it would be great to see the CARE Act posted on posters in every patient's room so every family has the right and ability to read about what their rights are for their loved ones before they are discharged from a hospital. Thank you for your time. I am at work today, but I would like to stand for any questions that you may have.
Thank you very much, Ms. Fowler. And committee, do we have any questions? We have one. Thank you, Senator Clifford.
Thank you, Madam Chair. Thank you for testifying this morning. Could you clarify me whether your mom's original discharge was an in-place discharge? In other words, was her status changed or before she went back to the care home she'd come from, or was she actually physically moved at that time? Thank you.
Sure. She left the nursing home, was admitted as an inpatient, where in fact they had her sign the letter for Medicare there, even though she was not competent. I should have been called to do that. She was admitted, diagnosed with pneumonia, had several bouts of dementia, very erratic behaviors. That information was never shared with the nursing home. When they discharged her, so she left as a resident. So her level of care changed when they discharged her to a skilled nursing unit level of care. I was not even notified of her discharge. I found out she was being discharged from the nursing home. I had been told earlier in the day that she would be remaining in the hospital for another day, so I was quite surprised. So her level of care did change from when she entered the hospital to when she was discharged, and then her level of care changed again within hours after her discharge to hospice.
Follow-up, Madam Chair? May I ask a follow-up? Yes. So she physically left the hospital to a different facility which had skilled nursing care rather than to the original nursing home. Am I correct?
No. The nursing home she was at also has a skilled nursing unit. The hospital assumed that when she went to skilled nursing, I would automatically choose that facility for her skilled nursing unit care when I could have actually sent her to a different facility for the skilled nursing care and then had her return to the resident, assuming she graduated from skilled nursing unit.
Okay, I understand. And then in the original facility, before she went to the hospital, was there a plan to put her on hospice at any point in her care? Was there DNR? What had you instructed them originally?
There was not, I apologize. Can you re-ask that question?
So since it was the same building or facility, in her prior status, was she DNR with a plan to go to skilled nursing if certain things happened? Did you have input on that?
Okay, she did not have a DNR in place before she left the facility. The plan was assuming that she received the care she needed and was healthy enough to return to the nursing home in the same status as a resident. That was the plan. However, since her level of care changed to skilled nursing unit, I, as her legal guardian and caregiver, should have been given an opportunity to choose a different skilled nursing unit facility.
Yes, thank you for clarifying that. And I'll tell you, my own father went through a similar circumstance with pneumonia and then change of status. So I certainly empathize with your mother's situation. Thank you, Madam Chair.
I have a question. So and by the way, I'm so sorry that this happened to your mother. When this did occur, I'm assuming she was on Medicare, is that right?
That is correct. And she
So-
had private insurance as well.
Okay, so were either of those, the private insurance or Medicare, was a grievance filed against the hospital, or where you felt like they didn't notify you? Was any action taken there?
Yes, and I did attach the correspondence I had with the hospital. I filed a grievance. I got a very generic response. And when I called the hospital to explain that I didn't feel like they understood the basis of my complaint, they told me to resubmit another letter, in which I did, and I gave bullet point by bullet point the whether the Caregiver Act or the KAR regulatory regulations, I'm sorry, were not followed. I included notes that in her hospital records that there was a note that there was no family by bedside. However, I was a phone call away. And I never received a response from that letter. And that letter was sent on, give me just a moment, August 22nd of 2023.
So then to be clear, the hospital did not notify you. They notified the skilled nursing facility, and they said, we are going to dismiss her. They never told you they were going to dismiss her?
Correct. I found out from the nursing facility that they were on their way to pick her up.
Okay, and had they attempted to reach you?
No.
All right. Any other questions, committee? Okay, seeing none, we do have proponent written only testimony. We will now move to oral neutral testimony. Tara.
Good morning, Madam Chair, members of the committee. I am Tara Mays with the Kansas Hospital Association. I appear before you today as neutral on Senate Bill 3 on behalf of our 121 community hospitals across the state. Certainly have a lot of empathy for Ms. Fowler and her family's situation. However, just want to point out to this committee that there are guidelines that we are required in hospitals to meet. When the Lay Caregiver Act went into place back in approximately 2018, we had made a good faith effort and commitment with those that were advocates of the bill at the time to really just, duplicate what was already being done in federal CMS statutes. Our conditions of participation do require already for us to do particular outreach to a medical caregiver when we are transferring or we were discharging a patient. In fact, in my written testimony on page 2, you will see the specific conditions of participation related to standards and requirements related to post-acute care services and transfers of those. I would point out in section D under III 2, there are some specific standards related to discharge planning and also informing both the patient and the patient's representative. There are a lot of avenues that if a patient or a patient's loved one or lay caregiver feels that that is violated, they can go and file complaints. One of those is through the federal CMS Joint Commission, which you have a link in your testimony online to file a complaint with the Joint Commission to say those standards have not been met through CMS. That will kick off an investigation from the Joint Commission of that hospital. There's also another avenue at the state level where if a family or a patient feels that this has been violated, they can call the Department of Health and Environment Services, and I've put that number in my testimony, and they can file a complaint. That also kicks off an investigation of our hospital. The truth is we see this a little bit as government duplication because we're already required to do this to be able to meet CMS standards, and we're already audited on that, and there's an ability for folks to file those complaints. So I would just say we don't have, as we see it, a lot of complaints from our hospitals regarding the Lay Caregiver Act. Certainly, again, empathetic of the situation that's been brought before you today, but we don't see this as some sort of thing that is bigger than one instance in this particular case. And so we feel like this is probably one of those things that's just government duplication. And I would point out that there is a pretty significant fiscal note that the agency has submitted to you related to implementation of Senate Bill 3. And so while we appreciate the sentiment and certainly understand the complications around some of these things, there are probably, as our hospitals tell us, far more patients that we see in our hospital walls that have no one available to provide guardianship care. And so if you were looking to make a significant state investment, we would certainly urge you to look more broadly than just the Lay Caregiver Act and talk about how patients are getting access to caregivers and guardians in the state of Kansas. With that, Madam Chair, I'm happy to stand for questions.
Committee, are there any questions for Tara? Senator Petty.
Thank you, Madam Chair, and Tara, thank you for being here. So I'm looking at that fiscal note, and it mentions that would increase administrative expenditures by at least $325,000. That's not talking about the number of the additional 2.3 positions that would be necessary to follow through with all of our hospitals. And you refer to 103. How many hospitals did you say?
121.
121. So you did follow up with saying if we were looking at expending this kind of money that you mentioned about it would be much better spent on, say that again?
Sure. We see a lot of patients that have no one there to be their guardians. And unfortunately, it provides a lot of patients and a lot of hospitals with the inability to be able to provide the appropriate level of care for patients. So if we were going to look at making that expenditure, certainly things like the guardianship and the program in the state of Kansas, we feel like would be a better place to make that expenditure and not government duplication.
Thank you. And so as you've shared with us, these kinds of, if there's a complaint or a concern about the kind of quality of care or discharge that has occurred, there is a process already in place.
Two processes. In fact, Madam Chair, there's both the process at the national level through the Joint Commission, and then there's also the KDHE process to file the complaint. So patients and their families have two process and avenues of remedy that they can go through.
Thank you.
Senator Clifford.
Thank you, Madam Chair. Again, to clarify, Ms. Mays, there's not an ombudsman in this situation like we'd have for long-term care, but KDHE has a process. Is that what you're saying?
Correct. KDHE, if they receive a complaint, it's our understanding that they will kick off an investigation of that complaint with the patient and the hospital involved. And so they will go through the process of finding out what happened, was it right or wrong, and then they will have the opportunity to implement, if things weren't followed correctly, any sort of financial fees, fines associated with that.
Thank you. Thank you, Madam Chair.
Senator Holscher.
Thank you. Thank you, Tara, for being here. I guess my question boils down to if there's two processes in place, then, essentially maybe what happened here to error on the part of the facility that was discharging her or something happened. I guess, I'm asking if those two processes were utilized, was there accountability? in that?
Well, I don't have the details from that specific hospital. Obviously, hospitals are very sensitive about sharing patient-specific information, so I'm not exactly sure. I think that would be a great question for, the agency or perhaps the proponents of this bill, if those processes were both followed, if both of those avenues were followed, what the remedy was. We just don't share that information back and forth for patient privacy reasons.
Senator Murphy?
Thank you, Madam Chair. Thank you, Tara. So it seems we had a problem, but how do we know, how does the average person in her situation know that they have these avenues?
Yeah, that's a great question. Thank you so much for the question of the average person doesn't get told when they come into a hospital setting, do you have a lay caregiver? Because let's be honest, if you all heard that language when you entered a hospital setting, you would probably be like, I don't know what the heck you're talking about. But when a person does come into a hospital, there are intake procedures just like there are discharge procedures. Those intake procedures require us to gather information about that patient, about their medical decision maker, about their guardian. The intake process very much dictates that we get that information for the back end and that discharge process. So that's how it is treated in every given patient situation. We, when a patient comes in, do our best and our due diligence to find out. For this instance in particular, we would ask the long-term care facility what records they have. If that patient is nonverbal and cannot tell us, we will do the best that we can to find out what that patient needs, who their guardian or caregiver is, and make sure that we're sharing information with them about the status of the patient.
Yeah, but it seems like a lot of that was maybe done, but then in the end, things fell through the cracks. And I guess my question really was, as Ms. Fowler, I believe, how did she know what her avenues of recourse were? She did what most of us would do. She contacted the hospital. But she could have contacted KDHD and might have elevated it.
Yeah, typically a hospital has...
But she doesn't know.
That's a great question. So typically the hospital has their own internal review process. So if a patient has a complaint, they may come to the hospital first. Typically the hospital will both respond with an internal investigation, but also allow, and it sounds like in this particular case, the hospital encouraged the person that was interested in filing a complaint, not only to file a complaint the first time, but perhaps file a complaint the second time. And they could file a complaint externally more than one time. So for instance, if you file a complaint with the Joint Commission because you're unhappy with what happened with your patients or your family loved one's care, you could file the initial complaint. If you're unhappy or unsatisfied with what that process looked like, you can file an additional complaint to either of those two places.
Okay, thank you.
I have a question for you. So is it typical in a hospital that if there is a power of attorney listed for a patient, that that individual, the guardian, would be notified at dismissal?
I think that is typical that we would be notifying them in compliance with the standard of conditions of participation as well as the Lay Caregiver Act, yes.
All right. Committee, are there other questions? Seeing none, thank you very much. This closes the hearing on Senate Bill 3, and since we will not be taking final action on Senate Bill 31, committee, we are adjourned.